Okay, well, welcome to the latest in a series of events we're running on the theme of why records management matters. This, as some of you may know, was originally planned to be part of a full-day conference back in March, which we had to cancel for the obvious reasons. So we decided to run the presentations as a series of lunchtime events, and they've been incredibly popular. Most of them have booked out almost immediately. Um, so at the end of today's presentation, it should last about 20 minutes or so, you'll be invited to ask questions. So if you could think about maybe just some questions you might have floating around in your minds just now. And to ask a question, you can either raise your hand, you should have a little hand icon, and we'll unmute you if you're muted, or you can just type in a question or a comment into the chat box. Okay, so without any further ado, I'm delighted to welcome today's speaker, Laura Irvine. Laura is a partner in Davidson Chalmers, and her talk is titled Records Management, Why It is Essential to Data Protection Compliance. And I should say that we are recording this event and we'll make it available on our website later. So I'll now pass over to you, Laura.
Excellent. So I will share my screen. Well, thank you very much for inviting me along, and John and I were just discussing how long it's been since this was meant to take place, so I'm delighted to have finally made it to this audience, and it's just a shame I can't see you all, but please do ask questions. My presentation today is a very, very quick canter through some of what I consider to be the highlights in terms of data protection law and why records management is so important in terms of compliance. But they're very much headlines in terms of the complexities of the law that exist, and the complexities of the issues that have been thrown up actually by COVID, by Brexit, and everyone's still really getting to grips with the change in law that was heralded by the introduction of the GDPR in 2018. Please, I encourage you to ask questions, and if you put them in the chat box as you go along, then I'll deal with them, at the end. But as things come into your mind, please do make this as interactive as possible. So my first slide is referring to these very unusual times that we are living in, and I've been talking about data and personal data, and this presentation is all about the use of personal data. I've been talking about how the issues have been highlighted during the COVID pandemic, and in particular, I think the app that has been introduced by the various NHS organisations throughout the UK, and of course many other countries in the world have similar apps. I think these apps have really highlighted some of the difficulties, some of the problems, and some of the concerns that individuals are having in relation to who's got their personal data, why have they got it, what is it being used for, who is it being shared with. And a lot of those issues can be addressed through getting data protection right, and a lot of those issues depend very much on effective and efficient data management, so records management and information management. So I think during the pandemic, trust has been talked about a lot, and trust in terms of personal data is something that GDPR was introduced to try and address for individuals, and it really was all about providing individuals with their rights, their data protection rights, and in order to use personal data now, organisations have to get the trust of those individuals, and that is a very easy thing to say, but it's not always a very easy thing to provide. And particularly in a technological way. So the app, again, good example of how our data goes into our mobile phone, but who else has it and how else is that used? Are they following us? Are they tracking us? Etc. etc. So really the delivery of information about what's happening with data is fundamental to getting that trust. GDPR came in, as I said, 2.5 years ago now, and the headlines were all about the big fines from the ICO. So yes, that's used to encourage our organisations we deal with to comply with the law and to deal with data, personal data, in a lawful manner. And the ICO has these powers to impose fines, and I'm going to talk about one of them in a minute. But I also do think that the power to take claims under the Data Protection Act and also to exercise the data subject rights that individuals have is probably the biggest driver in relation to compliance. So that's the kind of stick, but there's also the positive benefits to your customers and to your clients of getting this right and gaining their trust and then being able to provide that service efficiently and effectively. So there's been a number of actually quite significant data protection breach claims raised under the Data Protection Act, under the GDPR. So the Morrison supermarket case was decided by the Supreme Court earlier this year. The decision came out on the 1st of April 2020. But there are also claims against British Airways, who were recently fined by the ICO. The Marriott Group, again, recently fined by the ICO. And there's quite an unusual claim against Google in relation to the misuse of personal data by that big tech company. So these claims are kicking about and are really interesting from a data protection lawyer's point of view. But I'm also aware of a lot of smaller claims raised by individuals in relation to smaller organisations who they see as either having breached their data protection rights in terms of security or misusing their personal data. And for me, that should be the big driver in terms of getting compliance correct. So I did say I was going to talk about one of the ICO issued under GDPR, and this was the first one. It wasn't an enormous fine like the British Airways fine or the Marriott fine, but this company, the name amuses me very much. So Doorstep Dispensary is the name of the company, and they were fined £275,000 in relation to breaches of the GDPR. And this was all about their failure to manage information. And it's quite eye-watering, given, of course, the data that they had, which was medical information, so what we would call special category data under data protection law, and they had the patient records, which of course included personal data and medical data stored in the backyard of their premises in London. They were not, this backyard was not particularly secure, in that other residents of the property could access the backyard. And in addition, these documents were not stored in a very protected manner, and many of them had been destroyed by water getting into the places that they were being insecurely stored. So quite eye-wateringly poor in terms of security, but also I think what's interesting about the decision of the ICO to fine this organisation, it's much more about the wider management issues in relation to that data. That link on this slide is a link to the decision itself, and I would encourage you to dip in and out of that, read the bits that are relevant to records management, to data management. The fine was issued primarily because of a security breach, which is quite obvious, but there was also a breach in relation to the retention principle under the GDPR. So that's all about holding on to data for as long as is necessary and no longer. And the ICO were very quick to recognise that there was data being held in this insecure backyard that was much older than one would expect in terms of a pharmacy, and during their investigations discovered that actually there was no retention policy being applied by Doorstep Dispensary, and that's something that's pretty fundamental in terms of data protection compliance. The other failings that were pretty obvious to the ICO when they carried out their investigations were that basically this organisation didn't understand what they were meant to be doing with this data. They didn't even understand whether they were a processor or a controller, and that's quite a fundamental issue in terms of your obligations. So I won't go into any detail about that in this presentation, but it's something that's fundamental in terms of how you manage the information that you are holding. Are you a processor or a controller? Dispensary were a controller. They didn't have a contract with the organisation that they thought was looking after and shredding the data, and that again is a breach of the GDPR. No retention policy, as I said, and essentially the ICO discovered or concluded, sorry, that there were inadequate policies, inadequate security, and adequate records of processing. So that's one of the things that I think is very important in terms of records management and information management, something the GDPR introduced as an obligation, but something that a lot of organisations miss. There's a few slides here that are really just for reference, again, because we've got quite a short time. So I just wanted to highlight that these are the data protection principles. Lawful, fair and transparency. We'll talk a bit about transparency later. It's the fifth principle that talks about data retention, so storage limitation, and the sixth principle is about security. But organisations also must ensure that they have a good reason to have personal data and to process personal data. They need to keep the data that they have to a minimum in relation to that purpose, and also they need to have a system in place to make sure that the data is accurate and up to date. So that slide highlights the principles that I've just run through briefly, and the final principle, which I always like to refer to as a bonus, it's not, because it's very onerous for organisations. So that's the accountability principle, and this was introduced by the GDPR, and essentially that's all about managing your data correctly and not only complying but demonstrating that compliance. So lots of paperwork, lots of recording, lots of things that I imagine you as those involved in records management get very enthusiastic about. I do too, that is not a criticism, but accountability is fundamental, and it's something that the ICO focuses on whenever it's presenting out data protection and in the decisions that it's making in terms of the enforcement action that it's taking. That's really just for reference. That's the principle about data retention, so it's called storage limitation. Don't keep data for longer than is necessary for the purpose that you have it. And that's fundamental, I think, in terms of record management, and it's something that I have to say particularly lawyers are very difficult to reason with in terms of how long it is necessary to hold on to data, because they just like to hold on to stuff forever. But you can see in the circumstances of the doorstep dispensary, that caused them problems, increased the risk that they had, and ultimately increased the fine that they received for not looking after the data securely. I said I would talk about records of data processing. This is a new obligation that was introduced by the GDPR, so it's under Article 30, and that slide shows you the list of things that have to be recorded about data. And to me, if I was working with any organisation in terms of compliance, that has to be the starting point. So recording exactly what data the organisation has, what they're doing with it, why, and who they are sharing it with. You have to record the retention period as well, and then think about security measures. And often doing that recording encourages the conversations that then need to be had about compliance. So it's a good obligation to point to, and pretty much all organisations have to do this recording. And even if you don't fall into the category of requiring to do it, it really is required for most of the other compliance issues under the GDPR. And I'm going to come to those. So how would you use your record of processing activities? Well, for example, one essential, I suppose, use of the record is to make sure you are providing the individuals whose data you have with the information that's required under Articles 13 and 14 of the GDPR, so that you're complying with the transparency principle that I mentioned earlier. So that's all about privacy notices. Many of those were drafted and redrafted in the run-up to the GDPR coming in, and there is, on the next slide, again just for reference, a long list of the information that has to be provided to individuals. So where do you get that information from? It's from the record of processing activities. That record, by the way, is not something that just stays set in stone. It must be updated from time to time and reviewed from time to time. So your privacy notice is essential to comply with the transparency principle, but also I believe very strongly that it's essential to ensure that your data subjects, the individuals whose data you have, your clients, your customers, trust your organisation with their data. There were some quite good examples of privacy notices, privacy information, which the government in Scotland produced in relation to the tracking or the Test and Protect app as it is in Scotland. And if you are interested in this area, go and have a look at those privacy notices. I think they're quite brief, to the point, because they're all about one type of processing, but they tell you what you need, what information you need to give individuals, and that's in a particular context, obviously, but it is the same for all forms of data processing. There were two different versions for the Test and Protect information that hospitality venues had to gather. So at one point that was not a legal obligation, and then it became a legal obligation, you'll probably remember. So there are two different privacy notices, and again, it's interesting to look at the differences between those, because that informs all thinking about how to deliver that privacy information and what information is required in order to get that trust. That's the list of information that you need to give to people. I see many different types of privacy notices in my line of work, and I'm sure you do too. Some of them are pretty good. Some of them miss out some of this information, and some of them are very turgid, probably written by lawyers, and far too complex. The information needs to be given in a clear and concise and easy to understand manner. Another use for your record of processing activities. One of the new obligations under the GDPR was that for certain processing activities, you are required to carry out a DPIA. So that's a data protection risk. No, that's a data protection, risk assessment, effectively. It's required under the GDPR if you're starting a new processing activity that is likely to result in a high risk to the individual data subject. So that can cover a multitude of sins, but anything involving some special category data or large volumes of data would require a data protection impact assessment before you start. And actually the ICO encourage you to carry out DPIAs in circumstances which don't have that high risk attached. And it's a very, very good exercise to make sure that everyone's thinking about data protection. Issues like data minimization can be captured very, very readily in a DPIA, and thinking about just why you're doing something and what data is actually required for that, and can you minimize your risk effectively. The link there is to a template that's produced by the ICO, so there's several versions of that available. I find that template a wee bit overcomplicated. I like to keep the language simple, because it's not just your data protection officers or those who understand data protection law who carry these out, but anyone involved in the project. And then I did really just want to touch on this to finish off today, and it's kind of essential, so sorry I have to talk about it, but what does Brexit mean for data protection law? It's the GDPR is a piece of European legislation. We have left the EU, although the law is still in force in exactly the same way until the 1st of January 2021, and once that transition period ends, what will happen? it's a little bit up in the air at the moment, the kind of nuances of what will happen. In particular, the problem is going to be about international transfers, so transferring data not so much out of the UK to EU and EEA countries, but getting that back again. There's additional safeguards will be required to ensure that that is lawful and remains lawful. And there was a case over the summer which has made that a little bit more complicated. Essentially, the GDPR will continue in the same way. It will become a UK GDPR, and there are no proposals to change that in any significant way at this stage. However, things could change. What the government is aiming for and is still trying to negotiate is something called an adequacy agreement, which allows data to be transferred between the EU and other countries who the EU deem to have adequate protections in place and to provide the same protections to individuals. So certain countries have these adequacy decisions in place already. The UK would obviously like that, but there are complications around that adequacy decision, not least because of the surveillance that some of our security organisations are carrying out, which again was the subject of a decision in Europe earlier this year, which didn't quite go to plan for the UK. So complications in terms of the EU, but short term certainly things will progress as they were before. And if you are carrying out, if your organisations are carrying out any international transfers of data, then there are issues that need to be looked at and addressed. And the link at the bottom there is the link to the ICO's information about that. So that is a very brief, as I said, canter through some of the highlights and some of the issues that I certainly think of when I think about records management and data protection, and that, you know, the benefits that effective, good, proper records management can have in terms of compliance are limitless and absolutely fundamental to making sure that organisations, your organisations, get this right. So I will, I think, stop sharing my screen at that point, and if there are any questions, I'm more than happy to try and answer them.
Well, thanks very much, Laura. That was a kind of whistle-stop tour of GDPR compliance for records managers, and obviously there's so many issues, and you've really touched on I think that was the tip of the iceberg, and absolutely, with COVID and all the challenges it's bringing, and now Brexit, and what you've mentioned at the end, you know, there's a coming together here of quite a lot of issues that all of us will have to face. So I wonder, do we have any comments or questions from, we have about 40 people listening in today, so someone must have a question or a comment to make for Laura, unless you're all eating your lunch, of course. Okay, if you've got a question, if you just raise your hand and we can unmute you, or type into the chat box. Okay, Louise Anderson, Robert, if you could unmute. Hi, Louise. Yep, we're just waiting to unmute you. If we can do that, if we've got the technology. Not yet, sorry. Okay, well, just while we're waiting to work out how to unmute Louise, we have a question in the chat box from Ingrid Turner. Could you say more about secure information disposal? You mentioned the lack of a contract in relation to doorstop dispensary.
Well, yeah, so it's quite a common mistake that I think that organisations have been making for a long time. So doorstep dispensary, amongst others, outsource the shredding of their personal data, and the company that shreds the data it's what's known as a data processor. So it has personal data, but all it is doing is securely disposing of that data. And what's required, and actually what was required under the old legislation as well, is that the controller, so in this case Doorstep Dispensary, has a contract, a written contract with any data processor, in this case the shredding company. And they didn't have that contract in place. So one of the kind of excuses that they provided to the ICO was, well, hang on, it's not our responsibility because we've passed the data to the shredding company, so it's their fault and they should be fined. But the law says, no, you are the controller, Doorstep Dispensary, and it's still your remit to make sure that the processor does what it says it's going to do, and you have to do that by having a written contract giving those instructions. And if that contract doesn't exist, then that's a breach of the GDPR in terms of security. Before you get to any kind of responsibility for the processor. One of the things that was introduced by the GDPR was that processors can also be fined now, which is different from the old law. So that in this case, this shredding company could also face a fine from the ICO.
Okay, thank you, Laura. I'm sorry, Louise Anderson, I know you've had your hand raised and we don't seem to be able to unmute you.
Sorry, just say, Louise, if you unmute yourself,
yes,
you should be able to do it. Thank you.
Can you hear me? Can you hear me now?
Yes, we can, Louise. Yes, go ahead.
Sorry, I think that was my fault. I was not unmuting myself. I'm so sorry. Thank you so much for that. That was great. I'm actually I'm an archive manager, but I have some responsibility for records management. And I was interested in what you'd spoken about in terms of archiving and Article 5E, I think, which talks about archiving and the reasons, you know, that you can, you know, in certain circumstances, you can keep records. I come from a membership, a private members club, basically, and we are archiving members' records, but I just wondered what the position was with that. We're using it just for archival purposes, but are there any kind of special procedures that we should have in place for doing that? Does that make sense?
Yeah, no, it does, absolutely, Louise.
Thank you.
It's one of the conversations that I had with quite a number of organisations when the GDPR was being introduced, and actually, again, data retention was contained in the old law, but we all know the GDPR made people get very excited about data protection, so compliance with data retention is difficult. And in terms of what you're describing, archiving, that is one of the good reasons to keep hold of personal data. But what's really important for organisations is that they make a decision on what it's important to keep for archive for very good reasons, if you like, and what should not be kept. And that conversation is one that the organisation has to have. I would always recommend that the decision is documented so that if anyone, i.e. the ICO or individuals, disagree with your reasoning, you have that reasoning. And as long as your reasoning is not, like most lawyers would be, let's keep everything forever just in case, and you've actually thought through why you're holding on to the data, then that would be sufficient in terms of complying with the fifth principle. There will be, you know, there is kind of reasonableness limit to that, but in my view, thinking also about the risky nature of what's in your record. So if it really is contact information, then that's going to generally be quite low risk, making sure it's kept securely. So, you know, if it's online, you can archive, you can create a digital environment where everything is encrypted and locked down until you need to access it. So keeping those kind of security issues to the forefront of your mind, and in particular, depending on what that data is keeping the security in proportion to the risks involved. But it really is a lot about documenting your reasoning and making sure that you can evidence why you're doing something and you've thought about it.
Thank you. That was great. Thank you very much.
Do we have any other questions? No, it seems not. So if there's nothing else, then Laura, I think we'll end. Thank you very much. That was really fascinating. I'm sure that everyone really appreciates what you've had to say, and if we've got any questions after the event, then hopefully we can put them your way. So I'll ask everyone now just a virtual round of applause. Remind you that, and we're getting lots of thanks coming in from people. Just remind you that we have one event that still has some places available on the 3rd of December with Laura Miller and Anthea Seles at 5 o'clock. So if you go on the SCA website, you'll find details of that. So once again, thanks everyone. Enjoy your lunch, and thank you, Laura. Thank you.
Thank you.
Bye-bye.
Bye-bye.